In the case of Lucy Letby, it is universally agreed that no one saw her doing anything wrong. As stated here in an article from the BBC, had someone actually seen Lucy harming a baby at the neonatal unit in the County Chester Hospital, the case might have been more straightforward, but no one did. There was no incriminating CCTV or DNA evidence either. The evidence against her was circumstantial. This is an agreed aspect of the court case and is not contested at all, as we will see reflected in the various sources that I'm going to go over in this video. Later in the BBC article, we see this comment regarding syringes in hospitals, and the BBC article states the problem is no one saw Letby doing this. Later still, in the same BBC article, it is stated, and while no one saw Letby poisoning either of the two babies, she was there when they started experiencing symptoms. Finally, in the BBC article, it is reiterated again that no one actually saw Lucy harm a baby. I should say, with regard to this, that the BBC has been the most reluctant media organisation to print or broadcast or communicate anything pointing to Lucy's innocence or this being an unsafe conviction. In this Guardian article, it is noted that there was no forensic evidence to prove Lucy's guilt, and no one saw Letby, who continues to maintain her innocence, causing harm. Similarly, I can't access this article from the British Medical Journal because it costs a lot of money or you need to be a registered doctor. But they again note that there was no forensic evidence to prove her guilt and no one saw Letby do anything untoward. This is an article from the Nursing Times in which it is noted that no one saw Lucy do something in a stereotypical fashion which was violent or malicious. This is the now infamous article from The New Yorker in which Rachel Aviv notes that no one ever saw Letby harming a child. This is a related article published in the Justice Gap in which there's a lengthy passage which I'll read out in its entirety. Eventually, Aviv said, this belief became the national consensus affirmed by the Prime Minister and politicians, and yet to believe that she was guilty required accepting a proposition that on its face was pretty outlandish, that a nurse who had been described as kind, caring and dedicated, even the police acknowledged that they could not find anything about her that seemed inherently suspicious, decided to start killing babies with diverse, unprecedented methods in such a discreet and masterly way that no one saw her doing it. This is from a Sunday Times article written by Lord Sumption, who was a Supreme Court judge, and in this article he notes that many of the circumstances surrounding Lucy Letby's conviction seem very speculative because no one saw Letby doing any of these things. And this is a summary of the Lucy Letby evidence written by the Jolly Contrarian, and in one of the sentences here he writes, no one saw Miss Letby do anything, no one suspected her of anything, the strongest circumstantial evidence incriminating her was that she was there. That's it. That is the clincher. Miss Letby was at work. In addition to that, people who worked at the hospital with Lucy Letby also acknowledged that they never saw her do anything wrong. Indeed, no one alleges that they ever saw her engage in any form of intentional harm. There's one example here of Dr. John Gibbs, who stated that no one saw her do anything to harm a patient. In previous videos, I've gone over the virtually 20 nurses' statements from the Thurl inquiry, all of which indicate that no one saw Lucy Letby do anything wrong and that no one suspected anything, and several of the nurses indicate their belief in Lucy's innocence. This is the statement of Janet Cox, which is the strongest statement of the 20. I'm not going to read every single one out in this video because I've done so previously. In this statement, Janet Cox states, I had no concerns or suspicions about Lucy's conduct. She was an exemplary nurse who is completely innocent of all the alleged crimes. And I'll just go on to read the next passage as well. Were you aware of any suspicions or concerns of others about the conduct of Letby? And if so, when and how did you become aware of those concerns? I cannot remember the exact dates, but do remember gradually becoming aware that certain consultants appeared to be trying to make Lucy a scapegoat for the increased number of deaths and collapses. This, of course, references in particular Dr. Stephen Breary and Dr. Ravi Jairam, and we've now heard Sir Jeremy Hunt, the former Health Secretary, say that there is a very real possibility that Lucy was indeed scapegoated at this hospital. Because of these factors, the case of Lucy Letby is an entirely circumstantial one. This is broadly acknowledged even by people who consider her to be guilty, and indeed in the Court of Appeal document here it is noted that the case was a circumstantial one. The definition of circumstantial evidence is evidence that relies on an inference to connect it to a conclusion of fact, such as a fingerprint at the scene of a crime. By contrast, direct evidence supports the truth of an assertion directly, i.e. without need for any additional evidence or inference. So, in this case, as mentioned in some of the documents we've looked at already, the fact that Lucy Letby is present is an inference. If someone had seen Lucy Letby do something wrong, it would be direct evidence. The prosecuting barrister in the Lucy Letby case was Nick Johnson, who is on the screen now for those that can see the screen. One of the most important aspects of this court case was when Nick Johnson delivered the closing statement for the prosecution. During this statement, Nick Johnson said the following: "When the mother of baby E and F caught Lucy Letby red-handed, she didn't realise what was going on." So this is a very explicit allegation that the mother of baby E and F caught Lucy Letby red-handed. So that would be direct, explicit evidence. That would be an eyewitness account in which someone saw Lucy Letby do something wrong. So I will leave it up to viewers to decide whether or not this is lying, but I would like to just go over a couple of documents in support of that. So, to this artificial intelligence platform, ChatGPT, I asked the following question. If there is a court case that is entirely circumstantial, which involves alleged deliberate harm against infants, and it is agreed that no one has witnessed a defendant deliberately harming any infant, but at one point during court proceedings the prosecution states that someone caught the defendant red-handed, is it reasonable to describe this as lying? Yes, it is reasonable to describe the prosecution statement as lying, or at least misleading, depending on the context and the exact wording used. The case is entirely circumstantial, meaning no direct evidence, only inferences drawn from surrounding facts. No one witnessed the defendant deliberately harming any infant. The prosecution states in court that the defendant was caught red-handed. Definition of caught red-handed. The phrase caught red-handed implies the person was caught in the act of committing the crime, and this usually constitutes direct evidence. If no one saw the defendant harming any infant and the case is acknowledged as entirely circumstantial, then claiming the defendant was caught red-handed is inconsistent with that. This inconsistency suggests one of two things. The prosecution is lying if they knowingly made a false claim. The prosecution is being reckless or misleading, using emotionally charged language that exaggerates the strength of their case. If the prosecution knowingly said something that contradicts the agreed upon nature of the evidence, i.e. there was no eyewitness or direct proof, and this was not later clarified or corrected, yes, it would be reasonable to describe that as a lie, or at least as a serious misrepresentation. This kind of statement could prejudice the jury, undermine the fairness of the trial, potentially be grounds for appeal or professional misconduct, depending on the legal system. In a court of law, precision of language matters greatly. If the prosecution misrepresents circumstantial evidence as direct, that is a significant ethical and legal issue. There are two more things to note at this point. Firstly, the statement about catching Lucy red-handed was made very early on in the prosecution closing statement and is something of a centrepiece of that statement. The reason for this is that the statement is made in relation to child E. And in the case of child E, the prosecution had to allege that Lucy engaged in some pretty unusual acts, when the evidence much more strongly points to this infant suffering a gastrointestinal bleed. So Nick Johnson has to introduce some other elements to explain how Lucy Letby could possibly be guilty of deliberately harming this infant, not least because she was the person who alerted Dr. David Harkness to problems with the infant. So I've gone on to ask a further question of this AI platform regarding why making such a statement during a closing statement may be more serious. So I'll go over this information now. Closing arguments are pivotal. The closing statement is one of the final opportunities for either side to influence the jury. Jurors often weigh closing arguments heavily when deliberating. A false or misleading assertion at this stage can have a disproportionate impact on the outcome of the trial. Prosecutors have a legal and ethical duty to present the case fairly, not merely to win. Making a knowingly false or misleading claim during closing, when the defence can no longer introduce new evidence, can be seen as prosecutorial misconduct. The phrase caught red-handed evokes a powerful image of guilt and direct evidence. If the jury accepts this claim as true, despite the case being entirely circumstantial, it could unfairly prejudice them against the defendant. This can constitute grounds for appeal, mistrial, or even reversal of a conviction. Now, obviously, in this case, as there are numerous infants, it would be very unlikely to result in a mistrial, and it would also be very unlikely to result in the entire reversal of the conviction, but it could certainly constitute an important ground for appeal. If the court determines the state was knowingly false, obviously that didn't happen, it could lead to professional discipline for the prosecutor, a judicial rebuke, or even jury instructions to disregard certain remarks, grounds for an appeal or post-conviction relief, especially if the conviction hinged on such claims. I certainly believe that the jury could reasonably have been instructed to disregard this remark, which is, I would say, categorically untrue, but of course that didn't happen. Making a knowingly false or grossly misleading claim, like caught red-handed in a closing argument when the entire case is circumstantial, is a very serious matter. It not only raises the issue of lying in court, but potentially violates the defendant's right to a fair trial and could amount to prosecutorial misconduct. Now, of course, the platform here is expressing this in quite a strong way. What I would say is that I could make my own assessment of this issue, and everyone watching this video can also make their own assessment. I think almost anyone's assessment is going to be that if it's agreed that Lucy Letby was never seen doing anything wrong, and then the prosecutor says in the closing statement that a parent caught Lucy Letby red-handed, then this is completely unacceptable and this is deliberately deceitful. I'm not sure that this conclusion here is strictly accurate, but I do think it calls into question whether this was prosecutorial misconduct and whether or not it was something that should have appeared in the court case. In my estimation, it definitely should not have appeared in the court case. In conclusion, a court case such as that involving Lucy Letby should have the highest standards of evidence, considering the consequences for the defendant. I think anyone would reasonably agree that introducing completely false concepts and evidence that are critical to convictions, which occurred in this case, during the most important aspect of the court case, near the very beginning of that statement, can be considered unethical, deceitful, and rather concerning. Finally, if you've enjoyed this video, if you could leave a like, then it would be very much appreciated. This helps make the videos and the channel more visible on YouTube. If you're not subscribed already and you've enjoyed the video and would like to see more content, please do subscribe. Again, this helps the visibility of the channel and makes content more readily available to you. And finally, if you'd like to leave a comment, then I do read all comments. I try to respond to as many as I possibly can, and I enjoy that process very much, so that again would be very much appreciated.